It's all about money. With your host, CPA and forensic accountant, Sam Rosenfarb.
You're watching It's All About Money. Nobody knows more about money than accountants. Hi, I'm Sam Rosenfarb. I'm a forensic accountant. I've been an accountant for over 30 years, and I can tell you from experience that most people are irrationally motivated by money. This show is all about educating you, teaching you all about money, how you can spend it, invest it, control and maintain money, and its proper place in your life. This episode of It's All About Money discusses financial issues relating to divorce. How much child support should you expect to get after a settlement? Does custody matter? What is deferred compensation? Have you earned any? Is your spouse entitled to any? With us are two of New Jersey's preeminent divorce attorneys. Jeffrey Epstein is a partner in the family law team of the Woodbridge law firm of Wilentz, Goldman & Spitzer. He's a fellow of the American Academy of Matrimonial Lawyers. Mr. Epstein is an active member of the bar and is a frequent lecturer. Charles Vuotto Jr. is a senior associate also with Wilentz, Goldman & Spitzer. He's practiced in the area of family law since 1986. He handles issues of property evaluation, distribution, alimony, child support, custody, visitation rights, and domestic violence. Mr. Vuotto has been instrumental in developing the battered women syndrome laws. He has prosecuted and defended various matters under interstate and international laws, including international child abduction. Mr. Vuotto co-authored a family law digest that has been disseminated to family judges and lawyers on a yearly basis since 1988. Chuck, is there really a problem with international abduction of children?
Well, I don't know to what extent it's a growing problem, but it's certainly a problem, and it's resulted in a treaty being negotiated between various countries, not all countries. And the United States is a signatory, not all countries are, and that's a problem.
International abduction. Abduction means taking a child from this country and bringing him somewhere else?
Or the reverse. In fact, I had a case a number of years ago where a man had, I believe, 5 children, and he took all the children. The oldest one was living here. He took all the children and he brought them to the United States. And
brought him to the United States from where was he living?
Australia.
Oh, he was living in Australia.
He was living in Australia, and he and his ex-wife were living in Australia, and he decided he wasn't happy with the situation there, and he brought them all here. And the wife retained an attorney in New Jersey and filed criminal proceedings against him. He was arrested. The children were taken, and went through an entire process.
Is it against the law to bring your own children to a different country?
Well, if you violate the terms of the custody decree in the country in which you reside, and they are a signature to the Hague Convention, or at least that aspect of the Hague Convention.
What is the Hague Convention?
The Hague Convention is the best way, I may not be explaining it correctly, but a number of treaties dealing with various aspects of judicial process, serving papers abroad, and the child abduction aspects of it is one treaty.
So if the country in which this is signed is part of that convention, then you can't violate those terms of the custody agreement.
Basically, there are very limited ways in which you could actually keep the child here. In most situations, the child would just be returned automatically to his or her home state.
So one parent can't take one other parent's child, even your own child, to another country if it's against the custody.
It's an interesting concept because dual citizenship very often comes into play.
Sure, I have clients. One is a British citizen, one is a U.S. citizen. They're married, they have kids.
Sure, and is it a vacation or is it a violation of a custody decree? Is it permanent or is it temporary? And international law, unfortunately, not only in the area of custody and divorce, but also generally, is a set of laws without a lot of teeth. It's very hard to enforce international law, and I think that the Hague Convention was an effort to make it a little more enforceable.
How did you get into doing matrimonial law, Jeff?
I had a very big lapse of judgment.
Is this something you decided in law school?
I think very few lawyers get into matrimonial law right off the bat. It's something that you tend to fall into, and in this case, that's what happened to me. I was a commercial lawyer in New York, and I came to New Jersey because I had an opportunity to practice matrimonial law, and I was surprised at the breadth of matrimonial law. It touches upon so many different kinds of subjects: real estate, accounting, criminal matters, financial issues,
Emotional
all
issues.
sorts of stuff. And you really nowadays have to be aware of a lot of different aspects of law to practice matrimonial law.
Chuck, how did you get involved in doing this kind of divorce work?
Pretty much the same way. It was defaulted into it. The firm in which I was hired out of law school was primarily a matrimonial law firm, and I just gained experience and knowledge in that one area. One thing though I noticed is that, following up on what Jeff said, is that you really span many areas of the law and many areas of life, and you get into so many different aspects that you really have to hone your skills in a broader spectrum of abilities.
Is it there's a divorce every 30 seconds in America. I read that somewhere. Is it the attorney's job to attempt to reconcile a marriage? Is that?
So I've done that. When I think there's a possibility of reconciliation, the first thing I'll do is to refer the person to a marriage counselor or to give them ideas as to how a reconciliation might be effectuated. But usually when they've come to a lawyer, that decision is already made by the client and they're really ready to proceed and want to know what their rights are.
What's divorce mediation? What does that mean?
Well, mediation is something that's become more popular in the last 5 years or so. There really is no official training for divorce mediation, but generally it's an attempt by an attorney or a mediator. It doesn't have to be an attorney, as an accountant or even a psychologist or any layperson right now can do divorce mediation. It's an attempt to bring two people together without the litigation process and in a dignified way, minimizing the acrimony of a divorce.
Do divorce lawyers tend to stir the pot and create acrimony?
Some do.
Chuck, in your experience?
Some do. The really good matrimonial attorneys won't do that. They'll know when.
What makes for a good matrimonial attorney?
Well, someone who has the abilities in the various areas that are most important in matrimonial law. You have to be a therapist to a degree. You have to be an accountant to a degree. You have to be a psychologist to a degree. You have to be able to do all those things. But most importantly, I think, is you have to know when to put on the brakes. And unfortunately, some attorneys just don't do that.
Or if you were a client,
they'll
you met
fight
with
for
Jeff,
winning.
How would you know whether Jeff was a good? How should the clients know? How could
Whether
they tell?
you have a good attorney?
Yeah. Well,
First
when
you want to
they
look at
interview?
the attorney's experience and his credentials. Is it somebody that does matrimonial law as a sideline or 10% of his practice? Or is it some person, male or female, who devotes a substantial or all of his time to the practice?
You're a member of the American Academy of Matrimonial Lawyers. What does that mean?
It's a national organization. You have to take a test to become admitted. You have to have a minimum amount of experience in order to become admitted. And it's an organization devoted toward improving the quality of the practice of matrimonial law.
Is it better if your lawyer has extensive experience in matrimonial law as opposed to just partial, just uses it as a sideline?
Well, today it's essential. Years ago, when divorce law was far less sophisticated, before equitable distribution and before valuation issues came into play, you probably didn't need a specialist. Nowadays, there are specialties within the divorce specialty. You talked about international abduction cases. There are matrimonial lawyers that focus their entire practice just on that aspect. And there are matrimonial practitioners that just do appeals. So it's a very unique specialty now, and it's something that it really has to be, it's a learning process. Attorneys are becoming much more technical, and they have to have much more expertise than they ever did before.
You mentioned equitable distribution. What does that mean, Chuck?
Well, basically, there are statutory factors that a court has to look at in dividing assets that were acquired during the course of a marriage. Some states are community property states. Some states are, there may be some title states left wherein the property goes according to who owns it, but if there are any, they're very few. I mean, basically, equitable distribution is...
So New Jersey's an equitable
Yes.
distribution state.
Right, and basically the court will look at all these different factors, who brought what into the marriage, what are the ages of the parties, the health of the parties, where are they going to wind up after the divorce is over, what are they contributed to the various properties, and a bunch of other factors, and in making equitable distribution. For the most part, although these factors are important, in a long-term marriage where assets were acquired all during the course of the marriage, the court is going to divide the assets 50-50 for the most part.
Typically it's 50-50, is that?
In a situation where there's a long-term marriage and Even if one spouse worked outside of the home and one spouse worked inside of the home, the court is going, there are presumptions that that was a substantial contribution to the marriage, and the court is going to take that into account.
There have been recent changes in the child support guidelines. What is that all about?
Well, the child support guidelines were in effect for a long period of time, and there's a fairly strong men's lobby in Trenton that felt that they didn't give enough attention to the amount of time that non-custodial fathers spent with their children in terms of the economic ramifications of that. And also because of the economics of our country and the expenses of raising children, they needed to be revisited. What happened is there was a drastic change in the child support and the way it's calculated.
I mean, under the old rules, whether a father visited with his child or didn't visit, the amount of child support was the same.
Right. It didn't matter how much
Didn't
time
matter
they
whether he
spent,
visited or didn't.
unless it was basically a 50-50 type of situation.
Well, actually, the old guidelines presumed 1 night a week visitation in actuality.
That was the presumption.
That was the presumption in the old guidelines, and now they have taken into account the fact that you're not going to just be concerned with making the custodial parent whole. You need to take into account the fact that there are other expenses which go with the child.
So how did they do that? What did they do?
Well, you got it. First of all, I want to point out that the jury is still out on these new guidelines. My first reaction, and probably Chuck's first reaction, and a lot of lawyers, we hated them. We wanted to throw them away because you used to look at a chart and you had the child support number. Now you need a computer program. The judges are equipped with computers, and every lawyer now has to have a computer program to plug in the numbers. And so it's probably made it more expensive to calculate your child support.
Because you need to hire somebody to calculate it rather than just looking at charts.
There isn't going to be situations where people are going to be, lay people without the programs, without the charts, and without the know-how are going to be able to calculate their own child support.
Under the current guidelines.
Right.
I know at our firm we've purchased the program to have the child support guidelines accessible to us, to our associates.
The good news is they increased the net income, which applies to the guidelines, from $50,000 per year or $1,000 a week to over $150,000. And there's a huge difference there, so that there's much less mystery once you're able to plug in the numbers and come up with a child support number.
What does that mean, Chuck, about the guidelines and a maximum? Tell our viewers how that affects them.
Under the old guidelines, you could not apply the guidelines if your net income exceeded $1,000 per week.
So what did you do? No child support if your income exceeded $1,000 a week?
What happened is people extrapolated.
You got a good lawyer, that's what you did.
What happened is people extrapolated. You see, the guidelines represented a percentage of that weekly net income. So at one child, it was approximately 20 or 21% of the combined net income. So what would happen if the combined net income was $2,000? Well, to a large degree, the people would, the lawyers and even the judges would say, well, we're going to take that $1,000 and we're going to, or that $2,000 and we're going to double it. Right. Or we're going to maybe reduce the percentage a little, and they would extrapolate it out. But the bottom line is, under the new guidelines, which are based on much newer surveys and statistical data, the old guidelines were based on data from 1970 and 1972. Actually, and they were enacted in 1983 or 1984.
It only took them 10 years, right?
The old guidelines were based on the best data that was available at the time, because before the guidelines were enacted, they actually they did a survey and they noted that judges were going all over the lot with child support awards. And New Jersey actually was one of the first states in the nation to enact child support guidelines even before the federal regulations came down.
We need to take a short break. We'll be right back with Chuck Vuotto and Jeff Epstein, talk about how much child support you should expect.
That's my best friend, Jake. A few years back, his brother died of AIDS. It was the hardest time of his life. Mine too. That's why when Jake asked me to volunteer in a kitchen that prepares food for homebound people with AIDS, I knew I could make a contribution. At first, I did it to make Jake feel good. But after volunteering a year now, I do it to make me feel good. You can help. To find out more about the food service provider near you, call the number on your screen.
Hi, this is Sam Rosenfarb. You're watching It's All About Money. We're here with Chuck Vuotto and Jeff Epstein from the law firm of Walentz, Goldman, and Spitzer, talking about child support, how much you could expect, how much you expect to pay, and how much you could expect to receive. Chuck, right before the break, we were talking about how the new child support guidelines have changed and how the old guidelines, guidelines pertaining to the amount of child support people should expect to pay or receive, were based on old data, 1972, you said.
Right.
How do the new guidelines differ? What's the difference between somebody making $50,000, $60,000 a year and the amount they pay under the old guidelines versus the new guidelines? What's some other example?
Well, we have there's an example that I can give that was done in a recent seminar. But just to finish up on the point that I was making before, the new guidelines go to, as Jeff was saying, $150,800 net per year. And the figure of the child support amount, even under the tables alone, is much lower under the new guidelines at the upper income levels and in situations where there's multiple children than under the old guidelines.
So the new child support guidelines are better for those people paying child support than the old guidelines?
To some extent.
So this
when
is
you
where
get into the big money.
So this is where the men's lobby came in. They lobbied for these.
And also the big issue is that you get a deduction or a credit for the amount of time you spend with the child and maybe the expenses incurred in exercising visitation.
There are a number of credits. It even goes further than just the change in the percentages. It goes, there is a credit for the number of visits, and if the visits exceed 2 overnights per week, it actually changes the entire picture to a shared parenting situation where there are even additional credits that the non-custodial parent or the parent of alternate residence, as it would be called under a shared parenting situation, would be entitled to.
How do you know in advance how many days per week somebody will take the child? You know how many days they're entitled to take the child, but how do you know how many days they will take the child?
That's such a good question that it probably would take up 2 more shows. But it's a very inexact calculation now. It's hard to do child support until you know A, how much alimony there may be paid, and B, how much time the non-custodial parent is going to be spending with the kids.
So there'll be a lot of litigation over whether or not child support's been overpaid or underpaid based on these new guidelines.
Well, you talked about the men's lobby. The women's lobby is saying the non-custodial parent now is going to ask for a lot of time, even though he may not even want it, because he thinks he's getting a credit against his child support for all the time.
There's a provision in the guidelines have been made much more complicated, and there are many provisions for credits, and then even rebutting those credits. For instance, the credit for additional days, if the non-custodial parent doesn't exercise them, there's a provision for the custodial parent to go in and take the credit away.
So the theory was under these new guidelines that if presuming it's the mother who has custody of the children and the father who doesn't have custody, if the father sees the children and takes care of them during the days that he sees them, then he should pay less than if he doesn't see the children.
That's the theory, and
that's the theory.
It makes sense.
Good theory.
He has to get a 2-bedroom apartment as opposed to a 1-bedroom apartment. Right. He has to spend more money on vacations. He has to have more things in place in his own house and in his own world to take care of those kids a substantial amount of time.
The current guidelines are basically broken down now into 3 main components: fixed expenses, variable expenses, and controlled expenses.
Sounds like you have to be an accountant to figure out how much child support you need to pay.
Good business for you.
It's great for accountants.
So the fixed expenses are the shelter expenses and things like that. The variable expenses are clothing, I strike that, not for clothing, food and related expenses, and then there's controlled expenses such as clothing and things like that. I think I've broken them down correctly.
I have a personal favorite part of it, though.
Yeah.
It used to be, if your kid goes to college, there's still a presumption that you're paying child support pursuant to the guidelines, or maybe you get a slight credit for the amount of tuition you're paying. Now, 18, they're cut off. That's it.
No more child support
No more
after
child
18.
support. You recalculate it, but I think, and this has not been played out yet in the courts, there's going to be a strong presumption on limiting the amount of child support you're paying if your kid goes away to college, which I think is a fair and development in the new guidelines.
But under the new guidelines, if child support ends at 18, why would there be any child support if your kid goes to college?
It doesn't. It
doesn't exactly end.
You
it's
don't calculate it under the guidelines. The guidelines don't apply any longer. But there still could be child support, but you would calculate it under the old statutory, not the old, but the statutory factors.
Because as you know, just because your kid goes to college, that doesn't mean they don't have allowances, clothes, books.
I know because I've
video
had
games.
4 who have gone to college, and
Right.
and I know that the money continues even after they finish college. The money continues. Let me tell you. So I don't understand the difference between applying child support with the guidelines and applying child support with the statutory provisions. How would you know how to apply those?
Well, the statutory provisions would be what are the needs of the child, what are the incomes of the parties, or various factors dealing with actual expenses.
Very discretionary.
And,
So
and it allows
unless the husband and wife have agreed to this in advance, there's another additional litigation.
Which is more reason that you really need a good lawyer when you negotiate this thing to prepare for those kind of things which are going to happen. And I think you'll find more people now making and affixing the responsibility for college earlier on than they did in the past.
Do many divorced couples, after they're divorced, after they settled, either by settlement or by a judge settling it, do they go back to court? Is that common?
The war is never over.
It's not.
Unfortunately, until maybe the kids become emancipated. But
By emancipated, you mean no child support's paid anymore?
right, since there was a major case in this state, Lepus versus Lepus, which allowed for modification based upon changed circumstances. Circumstances invariably change. And when they change, you have to either go back into court or work out an agreement. You may find, as you spoke of in the earlier session, mediation beginning to play much more of an important role in bringing people together to avoid going back into court once the divorce is over.
Can the parties agree in advance to mediate further issues in their initial settlement?
They often do.
Sure.
They can, within their divorce agreement.
Many times, in terms of custody and visitation issues especially, we'll put in provisions where if the parties have problems with custodial sharing and visitation, that they'll go to a mediator, because very often those are the issues that come up immediately, and if they have to come running back to attorneys every time that they can't decide on what time to return the child or who gets who for what birthday, it
gets very expensive.
Exactly.
How do they decide what do you put into your agreements as to how they find a mediator? What source do they look to go to a mediator?
Usually choose it in advance, and what I'd like to do is use psychological experts who have been appointed by the courts and I have experience with, and I trust their judgment, and someone who I know.
So you name an individual rather than an organization like the American Arbitration Association?
Typically, although you don't have to. You can say it could be a mediator approved by the American Academy of Matrimonial Lawyers. It could be a mediator approved by the New Jersey Association of Mediators. But as it is now, there's not one central place to look for a mediator.
But that is an option for people to agree on mediation for future issues after they settle their.
It's becoming very common.
What are some of at the beginning of the show? I talked about deferred compensation. What is that? What does that mean? Deferred compensation.
Some people might say it's a way to hide income. And some people might say it's another source for income for purposes of paying support and alimony and child support and things like that. It basically, and you probably would be able to certainly add to this from a technical point of view, from a lawyer's perspective, it's income that's not necessarily or readily observable or reportable that certainly goes to a spouse and should be relevant within the overall support scheme.
So if an employee works for a corporation where he's entitled, for instance, to a bonus at the end of the year, or a bonus in 5 years, or 10 years, or 20 years, depending upon performance, that could be a form of deferred compensation.
Right.
Or a stock option, for instance.
Or stock options.
Stock options are very interesting because there are a lot of factors that come into play in trying to value them. It's not necessarily the price in which it's the strike price or whatever it's called that the option can be exercised.
It's not only its current price, but what it could be worth.
What
in
it
the
could
future.
be, and also what was the cost to the company? What was the value of the company at the time? What are the discount factors?
And what was the reason for awarding the option? Was it for future work with the firm to hope that the person has incentive and continues to work there, or was it a reward for past performance? That all becomes relevant if you consider it an asset for equitable distribution.
And is it considered an asset for equitable distribution?
Generally, it
Could
is.
be.
It depends when it's awarded and what reason.
Life insurance is another one of those potential deferred compensation issues.
I have an interesting story about life insurance. I represented an individual who was, sadly enough, was dying of AIDS. And there were $500,000 worth of life insurance that was owned by the wife. There was no cash value in these policies, mind you, which is 99% of the time the way people look at life insurance policies in terms of equitable distribution. The only value to these policies was the fact that they were on the husband's life who was dying of AIDS. Benefit. And there was $500,000 in death benefits. The wife took the position that it wasn't an asset, it was just a contract right that she had. And she ultimately lost that position and agreed to settle.
She went to court on the position that this life insurance policy that she had on her dying husband
was
had
not
no
an
value.
asset. Was not an asset. Did not constitute an asset.
Subject to equitable distribution.
Subject to anything. It wasn't an asset. So that was the legal issue which the court had to decide.
That's a very interesting case because life insurance can have lots of value, especially if it's on somebody who's about to die.
Well, exactly. There's actually companies who buy. It's called viatical settlements. And there are companies who buy life insurance policies on terminally ill people. But at that point in time,
at a big discount.
At a big discount.
Well, it depends on.
Well, it's an interesting business. You buy these life insurance people, and then you sit at home praying that these people die.
Exactly.
Right. Makes for interesting, very, very interesting business. What are some of your interesting cases, Jeff?
Oh, there's so many of them. My personal favorite are palimony cases because maybe it's me, but I have a philosophical problem with palimony as a concept because it's a very difficult thing to swallow. There's no marriage.
Well, tell us what palimony is.
Well, palimony is a contractual relationship that arises out of two people who live together. Now, I've never seen it, but sooner or later there's going to be palimony cases for same-sex couples also. But the palimony cases that I've had, basically...
These contracts are usually not written.
They're usually not written, and one person says there was a promise, the other person said there was never a promise. And so it becomes very difficult to find out who's telling the truth and what the real facts are.
And it could be, because if a man and a woman live together and one promises to pay another, and that promise is broken, that could be enforced, right?
And but should it be if the relationship fails? If you promise to support somebody for the rest of their life and you break up with them after 2 months, does that mean you have to support them for the rest of their life?
Greed does unbelievable things. We've run out of time. Don't let the greed get you. This is Sam Rosenfarb for It's All About Money. We've been talking to Charles Vuotto and Jeff Epstein of the law firm of Walentz, Goldman & Spitzer. They've created a legal guidebook on divorce and child custody. If you have any interest in obtaining a copy of this book, write to me, Sam Rosenfarb, 75 Livingston Avenue, Roseland, New Jersey, 07068, area code 973-535-1300. Thank you. Thanks, Jeff.